All right, good evening, everyone, and welcome to the forum. I gotta get Eve back in here. All right, thank you for bearing with us, all of this Zoom technology. My name is Liz Elliott. I am the co-chair of the New Orleans Safety and Justice Challenge Community Advisory Group, and along with all of our co-hosts, which include Court Watch Nola, Orleans Public Defenders, Southern Poverty Law Center Action Fund, Innocence Project New Orleans, National Council of Jewish Women, League of Women Voters New Orleans, Crescent City Media Group, and Urban League of Louisiana. And I think I got them all, so I apologize if I forgot one. Tonight, we are going to be hearing from the candidate for Section E of Criminal District Court, Derwyn Bunton. I do want to make a note that his opponent, Rhonda Goode-Douglas, was invited, initially agreed to participate, and then has subsequently withdrawn. Eve Abrams is our moderator for this evening, and I turn it over to her, and I hope you guys enjoy and learn something tonight. Thanks so much.
Thank you, Liz.
Thank you.
Good evening, Derwyn. Derwyn, I have a long list of questions, and so I'm just gonna go and we'll hopefully get through them all, okay?
Okay.
All right, so what will you do to reduce obvious racial and ethnic disparities in treatment by the court system in New Orleans?
Well, first I want to thank everyone who arranged for this forum to take place, and to all of the sponsors who are responsible for putting this together. The question is a big one. But I think what judges can do, and I think what leaders in our criminal legal system can do, are many different things to deal with the racial disparities and the problems in our criminal legal system and how it treats Black and Brown communities here in New Orleans. I think one thing is just a basic dignity to give to people, and understand that you don't have to take people's humanity for them to come through the court. So I will, in my courtroom, refer to everyone with inherent respect, Mr., Miss, and by their name. I'm not going to split you into inmate, defendant. You're going to be who you are in my courtroom. It's a simple thing, but it's a mindset that places us in this space where we begin to carve people up through the system. Another thing I'm going to do is make sure that no one is being held in jail because they are too poor. I'm going to look at bail and bond for folks under my jurisdiction and make sure that their freedom is not simply lost because they can't afford to make bail. I think that is one of the things that it robs our communities of human resources, but it also robs our communities of wealth when they are trying to make those bonds and pay those bonds for themselves and their loved ones. So I'm going to make sure to do that. Another thing I think judges don't do enough of is simply standing up, being able to call out unfairness, call out inequity, and call out injustice. I think there's no such, I don't think judges need to sit and grin and bear it. They don't have to say, oh, well, when there are fake subpoenas and material witness warrants putting people in jail, witnesses and complaining witnesses in jail. There are things judges can do. They cannot sign those warrants. They can condemn the practice. They can hold folks in contempt. And those disproportionately impact poor Black and Brown communities here in New Orleans. So those are some of the things I think I can do as a judge to really address some of those racial disparities inside of our court system.
Thank you. So you sort of touched on this already when you mentioned bail and bond. Do you support full public funding of the courts instead of relying on bail, fines, and fees to fund part of the court's budget?
I, I think for the better part of, I don't know, 15 years, I've been saying uh, that our user paid criminal legal system is inadequate, unreliable, and unstable. I don't think that we should be relying on fines, fees, and costs placed on the backs of people going through the system to pay for the system. So yes, I would support full public funding for our court system, for our criminal legal system writ large. And I also support all of us being transparent in how we are spending the money that we are given and embracing data and information to share with our communities what is happening inside of our courts. It is hard, for example, to deal with racial and ethnic disparities, gender disparities, if you're afraid to look at the information that shows you how they're getting into the system. You have to know what you're confronting so that you can confront it. There's a great book called Good to Great, and there's a big part of that book called Confronting Your Brutal Facts. And I think we need to confront our brutal facts in our system so that we can craft ways to intervene and partner with community to find solutions to deal with some of that. And I think one way to be able to do that is get the conflict where we need poor folks moving through the system to pay for the system out of our criminal legal system.
Thank you. So we are living through a time of great social unrest, a global pandemic. What do you think is the biggest challenge facing our courts right now, and how would you address this if elected?
There's so many challenges to our courts. I think pandemic related, we have cases that are backing up. We have cases that are starting to stockpile because there's no way to move them through our criminal legal system. But what we're also learning during this time is that that those cases that aren't moving are not causing some great system of unsafety in our community. So I think we need to take a critical look at the backlog of cases that is being created and whether or not we can find alternative ways to resolve those cases. So I think that alternative case resolution has to be seriously discussed by all parts of the criminal legal system, because I think what we're being taught about this time is a number of things. One, we don't need to arrest everybody. Two, we don't need to jail everybody. And three, we don't need to prosecute everybody. And so for many decades, because we had this thing called jail and jails kept growing and we had all these forces designed to get folks into jail. Jail was the hammer that made everything else look like a nail. And I think what we're learning right now is there are other ways to deal with this, and we are just as safe, if not safer, and our communities are less harmed if we can figure out how to keep people in their communities and keep our families and communities together. And we're learning that as we wait for these cases to get into the courts, those folks, by and large, who are waiting are not posing giant safety risks to us. And maybe it's time to rethink whether we need to move forward with any of those cases anyway. So I would support the system, leaders in the system coming together and coming up with a plan that would provide some alternative case resolution, dismissing whole swaths of cases, just saying, all right, that's enough, and sort of not trying to push a bunch of stuff through the system just because it's there. We need to have a reason for moving it. And I would certainly support that, because I think that's going to be a huge problem when we start to come up, when we start to open up after the pandemic.
Great, thank you. As you know, the past 2 years have seen numerous stories about prosecutorial misconduct, from fake subpoenas to withholding evidence. What do you think is needed to address prosecutorial misconduct in the courtroom if it comes to light that a prosecutor has withheld favorable evidence, for example, in a criminal case, pre-trial, during trial, or post-conviction? Would you, as judge, file a disciplinary action against that prosecutor? Would you permit that prosecutor to continue practicing in your courtroom?
Well, I think, one, we can't tolerate this. Like the scales are already tipped so that the rules are in favor of prosecutors in a big way. Anyway, and we simply can't have them cheating to achieve conviction. Not in a place like New Orleans in particular, where we are both the incarceration capital of the world and the wrongful conviction capital of the world. So I would certainly, for folks looking, point to my history. If past is prologue, then folks should understand that, yeah, I'm going to say something if you cheat in the court, if you hide evidence, if you misrepresent, if you put in jeopardy the fairness and equity of the proceedings, I am going to say something. And judges can use their contempt power, they can use mistrials, they can file complaints, disciplinary complaints. They can file complaints against judges. I've done that. They can file complaints against lawyers. I've done that. They can get on the stand and call them bullies and cheats. I've done that. So I'm one of the folks who, I'm the only person in my race who has seen something and said something when it comes to abuses of power, and prosecutors cheating in the courtroom. But we also need reform. We need structural reform. It ought to be a crime for a prosecutor to lie about evidence, to withhold evidence purely to try and get a conviction, oftentimes sending someone to jail for long periods of time that are excessive, or in the worst cases, sending innocent people to jail. When that happens, we need to have a way for those who are harmed to find justice through the courts, with the ability to sue those prosecutors, getting rid of their immunity when they do those sorts of things, but also for the Attorney General or some other prosecutorial authority to bring charges. It should be criminal to try and get a conviction with cheating and withholding evidence.
Great. You already spoke about this a bit when you were talking about jails and the hammer, jails being the hammer, everything is the nail. I'm pretty sure you're familiar with the MacArthur Safety and Justice Challenge, and that the city of New Orleans has accepted funds from this challenge and committed itself to reducing the jail population through a variety of strategies and initiatives meant to address the economic, ethnic, and racial disparities in the criminal justice system. Sorry, there's a noisy bird here. Some of these include use of risk assessments in determining bail and bond, preference for release on ROR instead of bail and bond, and increasing efficiency in criminal cases. Can you talk about your familiarity with the city's safety and justice challenge initiatives and how you as a judge would continue to support the city's commitments to the safety and justice challenge?
Well, we've been a part of the Safety and Justice Challenge from its very beginning, partnering with the city to craft an application to the Safety and Justice Challenge, being one of the first participants when the city was awarded the grant award from the MacArthur Foundation. And we have continued to partner with the city in the Safety and Justice Foundation with the Safety and Justice Challenge grant. So we're very familiar with it. And I think that one of the things we want to continue to do, what I would want to continue to do as judge, is continue to be part of the conversation first and foremost, so that we can have a true sharing of ideas and maintain a spirit of innovation when it comes to our criminal legal system. I want to be part of a new wave of judges who come in curious and thinking about ways we can make change and ways we can reform. That has been what I've brought to the table my entire career, is successful reform. And I want to remain curious. I want to remain experimental. I want to remain innovative and be in the room, as Hamilton would put it, in the room where it happens, for some of these changes in our criminal legal system. And hopefully the court can have some programs that we manage ourselves as judges that help with this. So I really want to be part of that mix. But I also want us as a system, as leaders, to think about what has gone on in this time, to really sit back and observe, okay, we were able to get our jail population down to its lowest level in 40 years. How many of those policies can we make permanent? What did we do to make this happen? And how do we just keep doing that? Pandemic or not, what parts of what's working can we keep and not go back to business as usual when the threat of the pandemic is over? I want to participate in that thinking and do a real sort of deep dive and digest what we did. I know there were lots of moving parts when the pandemic hit with our criminal legal system. The public defender office was critical to moving folks out of the jail, but I also want to look at, I want us to think about what can we make permanent.
You've already spoken a bit about the damage that money bail causes. As you know, a person is innocent until proven guilty, but in New Orleans, on any given day, about 1 in 3 people detained are locked up simply because they cannot pay bail. As a result, as you mentioned, they are taken away from their families, their jobs, and they may be forced to plead guilty, which saddles them with a record for a crime they might not have committed. Moreover, setting bail without considering someone's ability to pay is unconstitutional. What is your position on money bail? What will you commit to do to ensure that people are not kept in jail simply because they cannot afford to post bail, and to drastically lower the number of people held in jail pre-trial?
Sure. Well, simply put, I don't believe in money bail. I don't think that this notion that bail keeps us safe is false. The first thing a judge does when they order bond is that they've ordered release. They've ordered your freedom if you can afford it. And that's what folks need to understand from the very beginning. This is not a decision on whether someone is dangerous, or whether it's, some sort of danger. It's about, can you afford to be free? And I simply disagree with that as a premise. And so while we work and while community works around us to make changes to that system, I think judges can do a lot to mitigate the harm or alleviate it altogether in some places. Expand the use of ROR, use it where it is certainly legal to do so. And for bonds, create a bond, issue bonds that folks can afford, that aren't going to force them to mortgage their homes or rob them of generations of wealth. There's nothing that says a judge can't issue a nominal bond for someone, $5, $10 to let them out. And I certainly would be looking at those kinds of immediate fixes while community makes the changes that we need to have made in our system legally. And I certainly would lend as much energy as I could to that. But while the power I do have, I would certainly use to keep, to make sure that poverty isn't criminalized in our criminal legal system.
So a new law was passed this year that allows a judge to decide not to assess a conviction fee. Will you impose conviction fees on those who are deemed indigent and represented by a public defender?
I feel like these questions were made for someone else. No is the short answer. No, for 11 years I've been the chief public defender for New Orleans, transforming that office into really from dysfunctional to award-winning with a lot of help and support. And the only way we did that was by partnering with community. And loud and clear, our community does not believe that we should be funding our system on the backs of the poorest and most vulnerable going through it. So no, I would not be assessing those fees.
Well, maybe this is a question for you, Derwyn. Let's talk about technology, such as texting system to remind those with a summons to appear in court. Some people think that this can assist the court in making its process and procedures more equitable and accessible. And I wonder what you think about this and what other ways you see technology assisting us to make the judicial process more open.
Well, I think I really want to, one of the things I really want to focus on once elected is bringing new technology to the bench in a whole host of areas. So I would certainly be in favor of a system of notifying and alerting clients and parties in court of their court dates, pending court dates, pending due dates. So a system of texting, email, all of the above, I think would be ideal for folks coming through, for all parties coming through the criminal legal system and who find themselves in our court. I also think that we need to use existing technology to better and more efficiently create our court calendars as well. And I would do that with the cooperation and input of all parties, prosecutors, public defenders, defense attorneys, and court personnel. Let's look at what's out in the universe in terms of technology that we can utilize to help craft our court calendars so that folks can come in at times that are most convenient for them and allow the most flexibility for the people who find themselves working in our court system.
Currently, the magistrate court commissioners who make essential decisions about whether or not bail and bond should be set are appointed through an extremely untransparent process. 13 judges, you would be one of them, sit behind closed doors and decide which candidate for commissioner should be appointed. There are no major qualifications required of the candidates. There are no conflict of interest forms candidates are asked to fill out, and there is no public input. Do you think this process should be changed? And if you were chosen as a judge, what would you do to persuade your fellow judges to change this process?
Well, I do think the process should be changed. I think it should be more transparent, and I think we should publish to our community what the qualifications for commissioner are. And I think there's places we can look to for support and as models. One is the federal court and its magistrate system. So when the federal court is looking for a new magistrate, they publish the qualifications, the application is online, and you can see what, if you want that job, what it requires and what gets put on the application. It also talks about the process, who's involved, how they're involved, and the ultimate decision makers and how the deliberations are supposed to happen. I think that's the way we should be looking at choosing our commissioners. And not to say that there's anything nefarious going on. The problem is we don't know if anything nefarious is going on because it is not as open to the public as we would like it to be. Again, I would tell my staff this all the time, this isn't our money. And I think we need to act like that and be able to show our work to our community and make sure everybody knows how these decisions are made.
You spoke earlier about setting nominal bail bond amounts such as $5, $10 when the law requires that a bail bond be required of a defendant. The federal courts have consistently demanded that criminal district court judges ask defendants whether they can afford court fines or fees prior to the court imposing such costs. It is insufficient for a judge to impose the fine or fee in an amount the judge believes is affordable. The question of affordability must be asked of the defendant, as you know. Yet CourtWatch Nola volunteers found that in 39% of all observations in criminal district court in which a fine or fee was imposed upon a defendant, the judge failed to inquire into the defendant's ability to pay. What can be done to ensure that judges follow the federal court decisions, follow the Constitution, and stop using valuable taxpayer money to appeal such constitutional decisions?
Well, part of the answer is just to ask, right? You can ask, and you can make an inquiry. You can place them. You can put them at the podium and simply ask. One of the other things we
Are
can
you
do.
talking about asking a defendant?
Yes.
Right, but just
Okay.
want to direct you that 39% of the time that simple thing is not happening.
Exactly. So that simple thing has a simple answer. Just ask. I would simply ask, can you afford it? But I grew up poor as a kid, and it's not something you want to really talk about. I say sometimes I did homework by candlelight, not because it was romantic, but because we couldn't pay the bill. And so being in open court, talking about your finances can be a very sort of intrusive thing, especially at the first instance as well. So I think we can go further upstream at intake when they're coming into our criminal legal system, and gather that information with some safeguards to make sure we don't use it to further punish people, so that you can look and you can place folks, but because we actually have this law in place, we have indigency defined in the law. And if someone is too poor, we can find that out at the first instance and perhaps even verify it simply on paperwork, so that when they come through, we know before we ask or before we set any bond or exact any kind of restitution, we can know beforehand how much they can afford. And we don't have to, in an open court setting, have them tell us about the food stamps they're receiving and how long they've received them, and the housing assistance and the job they lost, the disability they're on. I've been in court and watched that happen, and understand how sometimes that seems to it's a humbling thing for individuals, and I think we can do better than that. So, but even you can also, at worst, you can simply ask what they can afford and then move accordingly.
CourtWatch Nola has consistently found that judges will engage in off-the-record conversations, otherwise known as sidebars, pertaining to a criminal case. Sometimes important privileged information is placed on a sidebar, but often important information that would affect the case is also discussed on a sidebar and never allowed to be part of the record. Refusing to place important information on the record affects the defendant's ability to appeal his or her case, since the information placed on sidebar will not be part of the official appeal record. What are your opinions on sidebars, and how do you propose to use or not use them if you're elected to the bench?
Well, my opinion on sidebars is that important information shouldn't be case-related. Important information shouldn't be in the sidebar. I do, though, believe sidebars have their place. Going to the side when you're talking about sensitive information, things that deal with witness safety or a person's safety, maybe someone's personal mental health or medical information. I'm not someone who thinks that all of that needs to be out in public and open and on the record. But if you're talking about things, and I'm drawing now from experience, right? If you're talking about things where the the prosecutor knows that a police officer is lying. This happened to me a number of times in my career. They go to sidebar and they show the judge this officer isn't being truthful, but they don't want to embarrass the officer. That's information that needs to be on the record. That's information that needs to be going up on appeal. That needs to be in the writ. Problems with the warrant, problems with sharing information that should have been shared. Discovery violations. There's a lot of times where those will go to sidebar. That's information that has to see the light of day. So it's hard because the public doesn't hear completely everything that's going on. But as judge, I would certainly, if a conversation starts with, I think we've got problems with this officer, I'm going to turn everybody around and we're going to talk about the problems with the officer. If it starts with, Your Honor, my client's HIV positive and just found out, I'm going to keep that at sidebar.
In 2019, CourtWatch Nola revealed that proper scientific testing was not being used by the Criminal District and Magistrate Court Drug Testing Lab. This lab tests the drug test samples defendants are required to take in magistrate and criminal district courts. Criminal district and magistrate court judges have continued to sanction defendants without proper testing, often sentencing defendants to jail when they supposedly fail presumptively positive drug tests. What would you do to remedy this problem and ensure that drug tests that are supposedly positive are in fact positive?
Well, one, in my court, there wouldn't be a bunch of drug testing. They have a probation or a parole officer, or they're in a program that does that testing outside of the court. So I'm not going to have a bunch of status hearings where everybody has to turn around and go test. We don't test for other medical conditions. So I'm not going to be testing for how much marijuana they have in their system at that particular point. So that's number one. But number two, upon learning that the lab is flawed, one, stop using the lab until you are sufficiently satisfied that they've cured whatever the problem is. And two, a judge can go back and review those cases and the decisions they made based on that information to determine whether or not they made the right call. The notion that you can actually acknowledge the mistakes you made at the bench, I know for some of my public defender brothers and sisters, is a novel notion. Judges are actually fallible and human. And if we're working on flawed information, we cannot be afraid to go back and say, this decision was wrong, and do what we can to cure it.
So beginning from the governor's stay-at-home order in March, CourtWatch Nola, and thus the public, waited over a month to have access to the Zoom proceedings that occurred for bail and bond hearings. These Zoom proceedings have continued, but the public was not allowed to see them. The public has a right to access all court proceedings, except in the rare case that the safety or the confidentiality of a defendant, victim, or witness is in danger. How would you ensure the public is never refused access to public court appearances again?
Well, one easy fix is to post as much as you can in as many places as you can the Zoom link or whatever link it is to the court proceeding and the time that court is going to be in session. So that way anyone with access to a computer can get to the link. We'd also have to make sure that our technology is sound enough and tight enough to be able to control those accessing it. We don't want to be Zoom bombed by folks. I've seen some very funny examples of folks invading the Zoom space who had no business being in the space. So we would certainly have to control and protect the integrity of the proceedings. Like that's, it's funny, but it's not a joke. We do want to make sure that that happens. But just making publicly, just posting, publishing the Zoom link, times that court is going to be in session, and getting with all the parties, all of the attorneys, the court personnel, to look at the docket and see if there's anything that is going to be on the docket that particular day that is going to require some specialized processes during the virtual session, and then you make accommodations for those. I've been amazed at how many different ways these virtual happenings make accommodations for, waiting rooms, and you can take polls and all these sorts of things. So I think the technology's there. We just have to do a little work.
The Louisiana Victim Bill of Rights requires a court to provide a secure waiting area during court proceedings, which does not require victims, witnesses, or homicide victims' families to be in close proximity to the defendants or their friends and families. The court usually does not afford this right to victims, making a criminal court proceeding an even more traumatic process. How would you change this?
Well, part of that is infrastructure, and part of that, I think, is also something that should be done case by case, and making sure that there's not a presumption that everything is going to be dangerous in the courtroom. But to the extent where we have the space, in our courts, I'm not sure we're even built for it sufficiently. So we'd have to get together with community partners to think about, okay, if we don't have the physical plant for this, how do we get it? How do we create it? And under what circumstances do we really need it? And then craft policies and procedures, and maybe, get some hammers, nails, wood to build some new things inside the courtrooms to accommodate this reality.
When a case moves from magistrate court to criminal court, Court Watch Nola has found that bail often remains the same or is raised, even if a defendant's number of criminal charges has decreased since bail was initially set in magistrate court. This occurs even when the case has no additional facts, when the only change is that the prosecutor has now announced the case is a felony. Do you think this is right, and should this practice be changed?
I think it's quite honestly the court's job to review at each instance any changes, and presumably the initial decision was based on the set of charges at the time. If those charges are reduced, then it's time to look at and possibly reduce the decision that was made at the first instance. In Louisiana, I think and this is where I think I bring a fresh perspective on fair justice in our courts, is felonies aren't magic, right? There's felonies in Louisiana are everywhere. So just because something becomes a felony does not necessarily mean that you have to raise the bail or bond or have more onerous conditions on someone coming through. I talk to colleagues from around the country. Drug cases are a prime example here. There's only one kind of drug you can possess that isn't a felony, and that's marijuana. Everything else is a felony. So illegal possession of prescription drugs, 19-year-old takes, a couple of tabs of Xanax from their mom, and that's the felony. Now, how dangerous that makes our community, I don't know. I don't think much. And so you'd have to make some decisions based on the facts and circumstances of the case, not because it magically became a felony or because charges magically fell away or even magically increased once getting into the courtroom.
So, as you know, as a defense attorney, there are no separate booths for defense attorneys to have confidential conversations with their clients in any criminal district courtroom. As a result, defense attorneys often must have extremely important conversations with their client about private court information directly in front of a co-defendant or other individuals who should not be privy to such information. While judges sometimes allow defense attorneys to use their private chambers, it's rare. How will you ensure you can have a private booth for attorney-client conversations in your courtroom, or otherwise allow room for these confidential conversations?
And again, here, much like the earlier question about, families who, families of victims and complaining witnesses, here, you got to look at infrastructure and you got to get with all parties as well. I remember being in court one time and watching there's a lot of problems with that scenario, but one of them is he's in open court saying this. Shouldn't be saying it at all, but that's a different forum for us. But at the same time, we need to have rooms and those spaces for consultation. We can utilize whatever we have existing, chambers, jury rooms, that sort of thing. And this goes for all of the required space. But it may require some build out. It may require some creative policies and procedures as well. And I would try and get all parties together to think about how we could do that.
So, a study released earlier this month by the National Registry of Exoneration concluded that concealing exculpatory evidence is the most common type of prosecutorial misconduct. Prosecutorial misconduct contributed to 78% of wrongful and false convictions in New Orleans. This is an alarming rate of misconduct. In fact, prosecutorial misconduct in New Orleans exonerations occurs at least 233% times the national rate. What are you going to do to ensure that prosecutors are not suppressing favorable evidence in the cases pending in your courtroom?
Well, I think one of the things that I can do and what judges can do is hold power accountable, and not just the line prosecutors, but their bosses and supervisors. We are all responsible for training our staff and making sure everyone goes into the courtroom prepared. So I think the problem is layered when it comes to that, and it's dangerous because I think there's this attitude that because these are poor Black and brown folks in the court, we're not going to work that hard to cure this. That I fundamentally dismiss. We're going to have to do some things. In the short term, holding folks accountable, dismissing evidence, calling mistrials, ordering new trials when it comes up later. Those are things that judges can do. I think we all need to be working with community and with each other's agencies to make sure that training is of the highest level and that we demand the highest level of practice from all the litigants and the highest level of decorum from all parties going through. Because some of the problem is simply not training folks well enough so that they screw it up and have innocent people in jail. That's part of it. Also part of it, though, is people whose incentive and whose offices' cultures have incentivized winning over all else, that gets them into a position where they will cut corners, where they will willfully cheat just so they can curry favor in their offices. And that is absolutely unacceptable as well. So I think, and with those sorts of situations, it goes back to what I said before, that's criminal, and we should treat it as criminal. The folks who are simply ill-trained or ill-equipped, we need to better our training. We need to up our resources particularly on the public defender side, so that we can call out these abuses and can ferret them out a lot better and a lot faster before someone innocent goes to jail and loses decades on their life.
So in a series of Brady cases from the U.S. Supreme Court, U.S. versus Aggers, Kiles v. Whitley, the court recognized that the significance of a piece of evidence and whether it is favorable to the defense team can seldom be predicted accurately until the entire record is complete. Therefore, the court opined that a prudent prosecutor will resolve doubtful questions in favor of disclosure. How will you make sure that the prosecutor follows the law and always chooses disclosure over suppression of evidence in the cases pending in your courtroom?
Well, I would review those cases and the literature out there on best practices for case administration and set timelines and procedures within our court with that in mind, so that we are going to have a tendency to support disclosure. We are going to have rules that support disclosure, and as much as we can, enforce those rules very seriously in the courtroom, so that it's not like, oh, well, no harm, no foul. We've been in that position before, and it's quite frankly awful and offensive to the poor folks who are looking for the courts to be fair. And there are a number of not just court decisions, but scholarly articles, writings from other judges who have ideas on how we can better control the flow of cases, so that we are accounting for just the kind of problems you outline. Having early disclosure dates, deadlines for it, and real consequences when they're not followed.
So this past summer, Act 110 was signed into law this past session, and I want to get your opinion on whether or not this is a solution to the user pay system and the question of judicial conflict. This is a law supported by the current judges in criminal district court. Is it something you would support?
I believe 110 is the fees collection law, right? And like I said, I certainly support publicly funding our court system. And so to the extent we don't have to collect any fines, fees, and costs, I think we're heading in the right direction. And to the extent that there's fines, fees, and costs, I think the courts have collected right now in escrow. I think there's some creative ways we can use what has been collected, but not really turned over as well. One, we can think about, how do we get it back to community? Or how do we invest it into things that don't add to mass incarceration, racial disparities, or problems in our system that way. So yeah, I support it, but it's not enough. And I think we're going to need more if we really want to end user pay.
Great, thanks, Derwyn. So you said earlier that you would, as a judge, you would call out injustice and unfairness. Judges often say their hands are tied. They can't do anything about an apparent inequity because of the way that the law is written. Is this a reasonable response when a judge's inaction contributes to manifest injustice? For example, there is currently no statute that permits imprisoned individuals to seek re-examination of fingerprint evidence in their cases. Yet there have been 2 exonerations in the last 2 years alone in Louisiana, Royal Clark and Archie Williams, in which the exonerations were a result of fingerprint evidence from their cases being reanalyzed and run through the National Fingerprint Database. So will you, as a judge, be creative in seeking justice and undoing wrongful convictions, even when there isn't a clear roadmap for doing so?
Well, the short answer is yes. I'm going to be the same person on the bench that I have been off the bench. And that is, I began my career trying to figure out how to reform these spaces, particularly in our criminal legal system, and their impacts on poor Black and Brown communities. And so in that work, I've had to be sort of creative. I've had to partner with others and with community, and with sort of with elders who have also worked to make these changes in our system. And yeah, I think there's things that courts can do to deal with that, and kind of force the issue, making, entertaining creative motions, uh, and having creative hearings that challenge something, that being a forum for innovation in the law. I think I would welcome that on the bench. I've said it many times to staff and in trainings. Gideon versus Wainwright, which is the seminal case for public defenders, gives us the right to counsel. And I say it all the time. Do you think Clarence Earl Gideon was the first person to ask for a lawyer? No, he was just the first person they listened to. And so you have to keep grinding. You have to keep working. You have to stay creative, curious, hungry, and innovative if you want to get these changes through. If you want to make our system fairer, more equitable, and more just, then you have to keep pushing the work. And I would be a forum that would welcome that kind of activity and work, and would not shy from where the law and equities align, making the tough decisions to try and move us to a better place as a criminal legal system.
Derwyn, I have a load of more questions for you, but believe it or not, we have 5 minutes left. And so I wanted to allow you to make any closing remarks you wanted to make. And thank you so much for your time. I've enjoyed listening.
No, and thank you, Eve, and thanks to everyone who gave the questions. The questions to date, these were by far the most rigorous questions I've received in a forum, and I really appreciate it. At my core, I'm a bit of a legal nerd when given the opportunity to be so. So thank you for moderating, and thanks to everyone who provided questions. The thing I want to let folks know is I believe my experience, my legal experience, my leadership experience, and my reform experience make me the best candidate in this race. I have stood proximate to folks most affected and in the shoes of folks most affected by our criminal legal system. And for 22 years, all I've done is pursue fairness, equity, and justice for vulnerable communities, for Black and Brown folks here in Louisiana and New Orleans. I can still remember sitting on a concrete floor across from a teenage boy who was naked because the institution believed clothes were too dangerous for him because of his serious mental health problems and his constant self-injuring behavior. And I remember sitting there asking him about his life and his treatment and thinking, how did we get here? And I moved from that motivated to reform these spaces. And that was when we sued the state for their unconstitutional conditions of confinement for our children. When we started, there were 2,000 kids in custody. When we were done, there were fewer than 350. We then passed the Juvenile Justice Reform Act, which improved the lives of our children statewide. I then began representing individual children in our courtrooms, and in that helped found what is now the Louisiana Center for Children's Rights. I moved from there to the Public Defender's Office post-Katrina, and I took an office that was called dysfunctional and unconstitutional. And then in 2015, 10 years after Katrina, it was named the best public defender office in the country by the National Legal Aid and Defender Association. I'm also someone who, when they see something, they say something. I have called out injustice in our user pay criminal legal system. I've filed when judges are doing the wrong thing. But what I'm most proud of at this moment is our parity statute that we were able to pass, because if we're going to have real fairness in our system, we have to begin to have the resources for public defenders whose job it is to protect innocence, fight for clients, and hold power accountable. If fairness and justice are the cornerstones of a criminal legal system, then it stands to reason the person who has pursued each their entire life is uniquely suited to be on the bench. And so I am thankful for this opportunity, and I really hope and pray for folks vote for number 89 on the ballot, Derwyn Bunton for Criminal District Court, Section E.
Thank you so much, Derwyn.
Thank you so much, Derwyn, and thank you, Eve, for moderating. I hope you guys all watching both here on Zoom and on Facebook, enjoyed that. We've got more sessions coming up. In fact, the next two are on Tuesday, the 29th at 6 p.m. at Section G, and at 7 p.m. at Section K candidates. So I hope you guys will join us then. Again, thank you to Eve and Derwyn for participating. Thank you to all of our co-hosts, Court Watch Nola, Southern Poverty Law Center, Action Fund, Innocence Project New Orleans, Louisiana Courts Matter, National Council of Jewish Women, League of Women Voters, Orleans Public Defenders, Urban League of Louisiana, and Crescent City Media Group. Thank you, everyone. I'm Liz from the New Orleans Safety and Justice Challenge Community Advisory Group, and we'll see everyone on Tuesday. Thanks again.
All right, thank you.